Good afternoon. This is the Supreme Court of the United Kingdom. We are continuing our hearing in the appeal of Shagang Shipping Company Limited in liquidation and HNA Group Company Limited. We are in the middle of the submissions of the respondents, and Mr. Edward Brown will be continuing his submissions. Mr. Brown.
Thank you, my Lord. My Lord, I'm proposing now to turn to the House of Lords judgment in Re B at MS page number 1424. My Lords, our submission is essentially threefold in respect of Re B and its application in civil litigation. First, the issues in a commercial trial are disclosed, certainly in the first instance, by the parties' pleadings. We say that in this case, the parties' submissions at trial did indeed reflect their pleadings. Second, there were two facts in issue in this case: the torture exclusionary rule and bribery. And the third plank of our submission is that a fact in issue was to be determined on the balance of probabilities, if necessary, by reference to the burden of proof. The consequence of that determination is set out in Re B, namely that it is determinative within that trial for all purposes. And we say that there is no principal distinction between admissibility and the application of this rule in general terms to any fact in issue. So if I may briefly develop the three limbs of those submissions. So first, the trite proposition that the issues are disclosed by the pleadings. For a statement of principle, see please paragraphs 21 to 22 of the Court of Appeal's decision in Al-Madeni, which is MS Supplementary 25. I don't need to turn to that now. But the point is this: it is up to Shagang, with the assistance of their legal team, to decide whether to plead the torture exclusionary rule. It is plainly a serious allegation. It requires proper consideration of the evidence by the pleader and a decision to be made as to whether or not to plead that issue. But if the pleader decides to do so, they take the consequence of losing on that issue. Second point, there are two facts in issue. See paragraph 5 of Mr. Justice Knowles' judgment, which I have shown the court. See also Shagang's skeleton argument at trial, paragraph 6 to 8, that is MS 413, and its closing submissions at trial, paragraph 3, that is MS 519. See also Shagang's acceptance in paragraph 9, paragraph 69 of its notice of appeal, that is MS 34, that the application of the torture exclusionary rule was a fact and issue in this litigation. So third, by reference to Re B, how does Re B apply in those circumstances? And the first question is essentially, is this a fact and issue? So were Shagang and indeed HNA and the judge right to treat the torture exclusionary rule as a fact in issue? And my Lord.
On your analysis, Mr. Brown, does it follow from the way you're putting it that if Shagang had not contested admissibility, they would have been entitled to rely on the torture evidence going to weight? And if
Yes.
that is your position, doesn't it turn litigation into a game of chance if your ability to rely on it in terms of weight depends on which side of the line the judge puts your application on the balance of probability?
First part of the question, the answer is yes, it does turn on that. Second part, the answer is no, it doesn't turn it into a game of chance. What it reveals is that litigation requires a judicial determination of the issues and the legal rules that have been identified by the parties in their pleadings. So I accept that it's a matter for Shagang as to whether or not it pleads the torture exclusionary rule. Where it appears we part company over the course of this appeal is that we say that having made that election with the benefit of responsible advice on it, we say that they are stuck with it. So if they choose to go down that path of invoking a legal rule, then they are asking the court for a determination on that legal rule. And as the House of Lords demonstrated in VB, that then determines the issue for all purposes within the trial. So that's simply how the rules of litigation have to operate. So my Lords raised the issue then about, in terms of the proper scope of a fact in issue. So what is a fact in issue? And Shagang and Liberty were unwilling to offer what I think was described as a unified theory. My Lord Briggs made the correct distinction between matters which go to credit and collateral facts, where the evidence cannot be challenged in cross-examination, and evidence which goes to primary facts, where that evidence can be challenged. Now, we say that the correct description of a fact and issue is set out in paragraph 2 of Re B. So see, please, paragraph 2, MS 1430. Lord Hoffman said this: if a legal rule requires a fact to be proved, a fact in issue, a judge or jury must decide whether or not it happened. There is no room for a finding that it might have happened. The law operates a binary system in which the only values are 0 and 1. The fact either happened or it did not. If the tribunal is left in doubt, the doubt is resolved by a rule that one party or the other carries the burden of proof. If the party who bears the burden of proof fails to discharge it, a value of 0 is returned and the fact is treated as not having happened. If he does discharge it, a value of 1 is returned and the fact is treated as having happened. So what is a fact in issue? It is precisely that. It is a legal rule which requires a fact to be proved. That is a clear and simple definition. You do not need, my respectful submission, to trouble yourself with the authority cited by Shagang, which is Cook and Cook, at MS 1761, judgment of Sir Thomas Plumer from 1823, which we say with the greatest respect simply does not assist very much on this issue. So the answer to the question is here, stated in paragraph 2 on the authority of this court. That then raises the question, well, is the torture exclusionary rule a legal rule which requires a fact to be proved? And the answer to that is yes. Yes, it is a legal rule. See A number 2. Does it require a fact to be proved? Answer yes. See A number 2, my lord. Lord Hamlin.
You accepted earlier that it would have been open to the judge to approach the issue of admissibility on a de bene esse approach. If he'd done that, would you accept that in those circumstances torture would not be a fact in issue?
Would torture not be a fact in issue if it's dealt with de bene esse?
Yeah.
No, I don't accept that. No. I don't know if my lord...
Well, what I'm saying to you, if he'd done an approach on a de bene esse approach, so he wasn't deciding the question, are you saying that that would it'd still be a fact in issue, torture in those circumstances?
Yes, I mean, whether it is a fact in issue is not determined by how the judge treats that fact in issue. So the fact...
Even if that's a perfectly legitimate approach, as you've accepted. What's wrong with him adopting that approach? And if he does, it's not a fact that he has to decide, and therefore it's not a fact in issue.
Well, perhaps there are 2 points to that. So it's a fact which he declines to decide. And so yes, but
acknowledged.
So does that itself mean it is not a fact in issue? Answer, no. Whether or not it is a fact in issue depends on the nature of the rule that's being invoked. Whether or not it's a legitimate exercise of discretion to decline to determine the fact in issue, I would respectfully suggest it is a separate issue. Now, I do accept that in the circumstances of this case, it might have been open for the judge to decline to determine it if he had done so in a cogent way and said what he was doing. So the fact in issue should be determined, but there may be cases where a court can legitimately, in the exercise of its discretion, say that is unnecessary for the overall conclusions. And see, for example, the way that the judge here deals with the further consequences of the bribery point, so the further factual matters which go to bribery, which are legitimately left out of account because of the way that the judge has treated other aspects of the case. So simply by a party saying, this is an issue, please can I have a determination, that itself doesn't require the judge to decide it. The judge still has his own case management discretion as to whether it's a necessary part of the judicial reasoning that he is embarking upon. But I would respectfully say that that doesn't in fact really answer the question as to whether something is a fact issue, which is ultimately to be determined by reference to what Lord Hoffman says at paragraph 2. Put another way, it can't be a fact and issue in general terms, but not be a fact and issue in a particular case. The torture exclusion rule either is or isn't a fact and issue. So my lord.
Sorry, I had to wait to be unmuted there. It's only a fact and issue, though, isn't it, for the purpose of the particular rule? There's nothing that Lord Hoffman says that suggests otherwise. It doesn't mean that because it's a fact and issue for the purpose of deciding admissibility, it's also a fact and issue for the purpose of assessing the weight to be given to evidence. That would be completely illogical.
Well, we respectfully say that the opposite must be illogical. That if one has a fact and issue which is serving two purposes within one trial, is it possible that one can have different determinations in respect of that single fact and issue simply because it goes to two issues in the case? And that is precisely the point that is dealt with in general terms in Re B. So it's not a point of specificity in respect of care proceedings. It's a general approach that if a judge is invited to, and it does, make a determination on a fact and issue, what then is the consequence of that? Can it come in through the back door? That's ultimately.
Let's take the example of a criminal trial where it's objected that a confession was involuntary. The judge finds it was voluntary. That doesn't stop all the same arguments being made again as part of the facts of the case itself after you've dealt with the question of admissibility of evidence, and the jury deciding, making up their own minds on all the evidence, including the evidence that goes to the voluntariness of the confession.
Yes, and it may be that that's legitimate in terms of criminal procedure, in the same way that in national security cases, there's also a slightly different approach to facts and issues, see A number 2. But what we're addressing here is an ordinary commercial trial. So issues determined on the balance of probabilities, and we say determined on the balance of probabilities for once and for all. So that's the issue that the House of Lords is grappling with in Re B. What do you do in an ordinary civil trial? Ordinary parties making their own decisions and their own elections about how they wish to pursue the litigation. And that's precisely what's happened here.
But if we were in the olden days and the ordinary civil trial would be before a jury, then wouldn't exactly the same split of function arise in context as well, that a judge might find himself or herself having to rule on admissibility and then the jury making their own assessment later on?
Yes, I see that. So the effect of that point is that it carves out a special rule in respect of admissibility. So the question...
Yes, but do any of the cases, or does Re B say anything about the rule that you propose in the context of admissibility?
No, it says nothing about that. So I accept that. And that is a point properly taken by Shagang and Liberty, that it may well be that there is a principled distinction which arises following on from Read B, which concerns admissibility. And the logical conclusion, therefore, is that if that is right, then my arguments on this point fall away. Because if Read B does not apply to questions of admissibility, and it is open for a civil judge to decide it one way and then decide it potentially in a different and inconsistent way, having admitted the evidence, then my point falls away. And I accept that entirely.
Thank you.
So the battleground is the principle in Read B effectively of general application in civil litigation. I hopefully dispose of Shagang's first argument swiftly, which is broadly to the effect that it only applies in care cases. Well, that's obviously not right with respect. See paragraph 2. Lord Hoffman is setting out a principle of general application in civil litigation. What the care context reveals in vivid terms is the situation where one can have a fact and issue going to two particular purposes. So the threshold criteria under section 31(2) and the welfare stage give rise to the care order. And VB falls then to be considered by reference to what was said in Re-H. So see paragraph 3 of Lord Hoffman's judgment, namely that that particular issue had been determined already to be a fact and issue in the sense described in paragraph 2. So that debate had already been resolved by the House of Lords. The threshold criteria issue was a fact and issue. So we say that it is sufficiently clear that the ratio of the case concerns the consequence of sequential determination of facts in issue within a single trial. And the short point is, if you determined it once in a particular way and returned a value of, say, 0, can you then reconsider the matter and, insofar as you need to return a value, return a different one, or simply factor it in terms of the overall weight exercise? No is the answer. See, please, Baroness Hale at paragraphs 30 to 31, which you've already been shown. So the clear ratio of the case is that findings made at the threshold stage cannot be treated differently at the welfare stage. One judge determines all of the issues. So see paragraphs 59, 70, 74. The fact in issue may have relevance to more than one question in the case. See paragraph 74. And the court says, on cases in which a court has two or more questions to ask in the course of a single hearing, the same factual issues are often relevant to each question. So we say that the authority of this court is that this is a principle of universal application. And there is no good reason to carve out admissibility as requiring some separate consideration of this principle. And we've noted in our written document through to paragraph 77 of Baroness Hale's judgment, which deals with the point that issues need to be decided. In particular, the concluding remarks in paragraph 77, for a risk to be real, it has to be founded on real facts, not unproven speculations. So that was the approach adopted by the Court of Appeal here in paragraph 60. On proper analysis of the judgment, the determination and the conclusion was no torture. That then follows through to the further matters, the further exercises that the judge has to carry out, whatever they may be. And that's the only workable way to operate a civil trial, which is why the Court of Appeal accepted the analysis. So the way it's expressed by Shagang and Liberty in their written submissions, we say respectfully, does miss the mark. So we're not disputing the fact that collateral facts and credit and things like that do not require binary proof. But what the judge does have to do is that if he is presented with the fact and issue disclosed on the pleadings, he's then, having determined it, got to follow through the consequences of that determination. So the torture exclusionary rule is an example of that. There are other examples. So another example, which I accept is in the context of admissibility, would be Section 5 of the Civil Evidence Act. So you have that at MS 1331. So this is another rule which requires there to be a determination of a matter, and there it is the issue of mental capacity of a witness whose hearsay evidence is alleged to be inadmissible under Section 5.1. So the position before court here would be an application made to exclude evidence, hearsay evidence that's otherwise admissible, on the basis of an allegation that, for example, the witness was in a state of delusion when the statement is made. The court has to determine that on the balance of probabilities. So was the maker of that statement in a state of delusion when the statement was made? If not, the evidence is admissible. Admissible hearsay evidence does not fall to be excluded. Having made that determination, the court can't then, we say, reasonably reduce the weight to be given to that statement on account of a possibility of mental incompetence or a state of delusion, having already concluded on the balance of probabilities that the person was competent to make the statement. We say that would be inconsistent and erroneous, and there is no principal distinction that has been offered to this court to why issues of admissibility should be treated differently from any other issue. So, my lord, that's what we say about VB. I want finally, just before I hand over to Ms. Boyd, who's going to make submissions in respect of A number 2, just to identify the fresh evidence so that the court has it. There are 8 items of fresh evidence that were admitted by the Court of Appeal. So investigation documents, if I may just read these into the transcript. So the MS references at 1165, 1175, 1178, 1182, 1186 and 1187. And there are also the judgments, so further judgments, in particular in relation to Mr. Gia H. And the references for those are MS 1264, 1290. You haven't heard very much about those. They went to central issues of credibility, not simply torture, as I think it was suggested by Shagang. I've shown the court paragraph 90 of the judge's judgment where he makes the point in relation to the testing of the PSB officer's account in China. That point has been demonstrated to be incorrect by reason of the fresh evidence. And the further evidence goes to the credibility of Mr. Zhang, who on behalf of Shagang signed a disclosure statement but did not disclose relevant and probative documents. That was significant. And the fact that it's not addressed in any meaningful way by Shagang in their written document and very briefly in their oral submissions does not mean that that is not an important factor which goes to the retrial. It does. It was a material part of the Court of Appeal's reasoning in addition to all of the points that I've shown the court. My Lord, that's all I propose to say about the fresh evidence, and unless there are any questions at this stage, I propose then to hand over to Ms. Boyd.
No, Mr. Brown, thank you very much indeed. I don't see any of my colleagues wishing to raise any further questions. Ms. Boyd. Ms. Boyd, I think you're still muted. You're clear now.
Thank you. Good afternoon. I am going to address your lordships finally on Shagang and Liberty's submission that the Court of Appeal's decision in this case was contrary to the House of Lords decision in A number 2. Now, as Shagang now cast this issue, this too is a matter going to the scope of retrial. It is not now offered as a basis for reinstating the judgment of Mr. Justice Knowles. My submission on A2 proceeds, of course, on the basis that you are with us on the effect of Re B and the proposition that a commercial court judge who has determined one thing on the balance of probabilities cannot in general thereafter take into account residual doubts about whether he was right, because if you are not with us on that, then Shagang doesn't need A number 2 to argue that the retrial can legitimately include torture. If you are with us on that, however, what we submit is that A number 2 does not help Shagang. It is not an alternative route to the conclusion they seek to establish, as has been submitted. On the issues that concern us here, it is not, we say, the lex specialis on how to deal with torture issues, torture allegations in any context. It is the lex specialis on torture issues arising in SIAC, and in particular, it does not establish that it is proper for a commercial court judge to entertain residual doubts about torture once he has found torture not proved on the balance of probabilities, whatever may be the case in SIAC. Now, Shagang and Liberty rely for their submission principally on one sentence in each of Lord Hope's and Lord Rogers' speeches, Lord Panic took you there yesterday. I don't ask you to turn it up, but you will recall that Lord Hope said at paragraph 118, if SIAC is left in doubt as to whether the evidence was obtained in this way, it should admit it, but it must bear its doubt in mind when evaluating the evidence. Lord Rogers said at paragraph 145, when everything possible has been done, it may turn out that the matter is left in doubt, and that using their expertise, SIAC cannot be satisfied on the balance of probabilities that the statement in question has been obtained by torture. If so, in my view, SIAC can look at the statement, but should bear its doubtful origins in mind when evaluating it. I'll refer to that prescription to bear residual doubts in mind as the residual doubts prescription. Now, Shagang and Liberty contend that the residual doubts prescription applies to any judge in any context who has found torture not proved on the balance of probabilities. We say that is wrong on analysis of the judgment in A number 2, but given the way that Shagang and Liberty advance their arguments, let me be clear about two things at the outset. First, we are not, of course, disputing the universality or the constitutional importance of the torture exclusionary rule itself, which plainly does apply in all judicial proceedings, subject to a clear parliamentary expression of intention otherwise, as per the judgment in A number 2. Secondly, it is not our position that the other findings in A number 2, including the residual doubts principle, apply in SIAC and SIAC alone. We accept that those findings would naturally extend to other jurisdictions that share certain of SIAC's distinctive features. The submission we do make is, in summary, as follows. Although the torture exclusionary rule is universal, the House's consideration in A number 2 of how that rule would apply in SIAC was acutely concerned with specific questions about how it could fairly and reasonably operate in SIAC's highly unusual environment, and I will show your lordships that by reference to the judgment. The unusual features include the fact that much of the evidence is closed evidence. There is, in consequence, a stark inequality of arms. One of the parties is the state, and the individual appellant in a Section 25 appeal, which is what this appeal to the House of Lords was concerned with, stands to lose his liberty on the basis of mere risks or suspicions without trial. Now, proceedings in SIAC under Section 25 are in those respects a million miles from ordinary, open, adversarial proceedings between private parties with equality of arms before a civil judge. As I'll show you in a moment, there is no indication at all that their lordships intended their conclusions in A number 2, save for the universal application of the torture exclusionary rule itself, to be carried over to forums sharing none of SIAC's features, quite the contrary. And there is a further, more specific point. We say that their lordships' unanimous finding that neither party bears the burden of proving torture in SIAC is a crucial point of distinction from proceedings such as these, and is a necessary premise of the residual doubts principle, which cannot coexist with a conventional approach to the burden of proof. Now, I'll seek to make good that submission by reference to the judgment, and then I'll address my friends' arguments that they made yesterday. So if your lordships would turn the judgment up, which is at Authorities Bundle 1, Tab 2, MS 1338. Now, as your lordships know, the context of this decision was the exercise of draconian powers enjoyed by the Secretary of State under the 2001 Act, the Anti-Terrorism, Crime and Security Act, to certify an individual as a terrorist suspect on the basis of a reasonable belief that he or she posed a risk to national security, or a reasonable suspicion that he or she was an international terrorist. On the basis of such certification, the individual could be deported or detained without trial. So the context is highly unusual, highly intrusive powers conferred on the executive in the interests of national security. Indeed, the regime was recognized to involve itself a compromise of fundamental constitutional principles, since it required derogation from Article 5 of the Convention. And all of those points are emphasized by Lord Bingham in his speech at paragraphs 3 to 4, MS 1360. I don't ask you to turn that up now. Now, SIAC's job under Section 25 of the Act was to review the use of those powers, SIAC being the sole forum for appeal or review. So although such review is obviously a judicial exercise, we are clearly already in an entirely different universe from that of private adversarial litigation in the commercial court. Now, the House in A number 2 was concerned with 3 issues, not just one. The first and central question was, did the torture exclusionary rule apply at all in SIAC? The great majority of their lordship speeches were devoted to that issue, and Lord Pannick has taken you to their speeches on that issue. Their lordships concluded unanimously that it did apply, of course, as it applied in all judicial forums, notwithstanding SIAC's national security jurisdiction and special evidential rules. There is no controversy between Shagang, Liberty and us as to the effect or scope of that finding. The remaining 2 issues, however, concerned the way in which the torture exclusionary rule should be applied in SIAC, given SIAC's particular jurisdiction and features. They were, first, who bore the burden of proof when evidence was alleged to have been obtained by torture, and secondly, what standard of proof should be applied to the question of admissibility. Now, on the standard of proof, the House was divided, as your lordships have heard. The minority, led by Lord Bingham, held that evidence should be excluded if there was a real risk it had been obtained by torture. The majority agreed with Lord Hope that it should be excluded if torture was established on the balance of probabilities. On the burden of proof, however, and my lords have not seen the speeches on this issue, the House was unanimous. their lordships found that neither party bore the burden of proof in relation to an allegation that evidence had been procured by torture, and that the burden lay instead on SIAC to investigate the matter itself. As I will shortly show you, for both the majority and the minority, these conclusions were intimately informed by and addressed to the specific context of a Section 25 appeal in SIAC. In the case of the burden of proof, the unanimous conclusion that the burden fell not on the parties but on SIAC was expressly recognised as one that did not carry across to a conventional adversarial context such as the present. Turning then to the judgment, I'd like to begin with the submission that was made on these issues by the appellants, taking it up at MS 1348 and at F on that page. If your lordships would please read from F on that page over to the end of the first full paragraph on the following page. Now, we emphasise the submission that even if the burden rests generally on the complainant where the proceedings are fully adversarial, it cannot do so in a closed evidence procedure. So the appellant's submission was specifically that it was wrong to impose a burden of proof on the appellant in a Section 25 appeal or any proceedings involving closed evidence because of the particular difficulties an appellant would face discharging such a burden in such proceedings. The submission was not that it would be wrong to impose a burden of proving torture on a party in any judicial proceedings, or that a special rule should apply when torture is an issue because of the special difficulties associated with proving torture. Now, the next paragraph of the submission recorded there deals with the standard of proof, and if your lordships would now read that. So again, your lordships will see that the submission as to the standard of proof was based on the procedural handicaps on an appellant on a Section 25 appeal or comparable proceedings. Turning now to Lord Bingham's speech, he addressed these issues beginning at paragraph 54 of his judgment, which is, give me, MS 1389. The beginning of paragraph 54 sets out the competing submissions on the burden of proof. The appellants contend that it is for a party seeking to adduce evidence to establish its admissibility if this is challenged. The Secretary of State submits that it is for a party seeking to challenge the admissibility of evidence to make good the factual grounds on which he bases his challenge. Could you then please read paragraph 55? We emphasise the words "this very unusual forensic setting." Lord Bingham goes on in paragraph 56 to explain that rather than either party bearing the burden of proof in this unusual forensic setting, SIAC should adopt an inquisitorial approach to an allegation of torture if plausibly raised by the appellant. Picking it up between G and H, he said, where such a plausible reason is given, or where SIAC, with its knowledge and expertise in this field, knows or suspects the evidence may have come from such a country, it is for SIAC to initiate or direct such inquiry as is necessary to enable it to form a fair judgment whether the evidence has or whether there is a real risk that it may have been obtained by torture or not. So that is the conclusion on which there was unanimity. The burden falls on SIAC. Lord Bingham then goes on to make his controversial finding about the standard of proof. If SIAC is unable to conclude that there is not a real risk that the evidence has been obtained by torture, it should refuse to admit the evidence, otherwise it should admit it. At paragraph 57, he says he will explain why he disagrees with the majority on that point. Then at paragraph 58, we have this. I agree, of course, that the reference in Article 15, that's Article 15 of the Torture Convention, to any statement which is established to have been made as a result of torture would ordinarily be taken to mean that the truth of such an allegation should be proved. That is what established ordinarily means. I would also accept that in any ordinary context, the truth of the allegation should be proved by the party who makes it. But the procedural regime with which the House is concerned in this case is very far from ordinary. A detainee may face the prospect of indefinite years of detention without charge or trial and without knowing what is said against him or by whom. So there is an explicit contrast there between conventional proceedings, in which the conventional approach to the burden and standard of proof would apply, even on Lord Bingham's analysis, to allegations that evidence had been procured by torture, and proceedings in SIAC which are very far from ordinary, warranting a departure from the conventional approach. So it is crystal clear in my submission that Lord Bingham did not intend these findings to carry over to ordinary civil litigation. Lord Nichols is next, and at paragraph 80 on MS 1395, he simply agrees with Lord Bingham on these issues. But if your lordships would have a look at paragraphs 77 and 78 preceding that, you'll see in paragraph 77, Lord Nichols makes reference to the various jurisdictions of SIAC. I'd like to draw your attention to paragraph 78, whether the Secretary of State may take tainted information into account when making decisions under statutory provisions such as these, and whether SIAC's function requires or permits evidence to be given of all the matters taken into account by the Secretary of State, are questions for another day. They do not call for decision on these appeals, and they were not the subject of submissions. It would not be right, therefore, to express any view on these issues. So Lord Nichols is suggesting that the ambit of the findings is not just confined to SIAC, but indeed is narrower still. It is confined to decisions in SIAC under section 25, and it would be wrong, he says, to go further without submission. Lord Hoffman next addresses the burden and standard of proof at paragraph 98, MS 1400. And could you please read that paragraph up to the word rebutted between C and D? So again, your lordships see that the features referred to and relied on have no analogue in ordinary adversarial disputes between private parties in the commercial court. The same is true of Lord Hope's consideration of the burden of proof at paragraph 116, MS 1405. And if you could please read that paragraph. At paragraph 117, he says that guidance also needs to be given on the standard at proof. And then at paragraph 118, which your lordships have seen, he sets out Lord Bingham's test and then his own test. And that paragraph is where he articulates the residual doubts principle. Paragraph 119 then goes on to explain his disagreement with Lord Bingham on the standard of proof. And if your lordships would please read that paragraph. So again, the factors weighing with him are all specific to SIAC. There is no suggestion that the discussion or the conclusions are intended to apply to forums that share none of SIAC's distinctive features. Lord Roger next did not specifically address the burden of proof, but it is clear that he agreed that a torture allegation raised an inquisitorial task for SIAC, and picking his judgment up at MS 1414, paragraphs 143 and 144, could I ask your lordships to read those paragraphs? And we ask your lordships to note what was envisaged as regards the nature and means of inquiry that SIAC would undertake. The government would do as much as possible, Lord Rogers envisaged, with the aid of the relevant intelligence services, and would submit relevant information to SIAC pursuant to its duty of candour. SIAC itself would wish to take an active role in suggesting possible lines of investigation. Now we say neither of those things is possible or appropriate in an ordinary civil trial where the state is not a party. Paragraph 145, the immediately following paragraph, is there then where Lord Roger articulates the residual doubts principle. Next, Lord Carswell's speech, picking it up at the end of paragraph 153, MS 1417. After H, you will see that Lord Carswell was conscious of the importance of laying down a clearly defined and workable rule which can be applied in SIAC or similar bodies which may have to deal with the same problem. So that is an indication of the scope he understood the findings to have. Paragraph 154 then sets out the problems he saw with imposing the burden of proof on either party in SIAC. And picking it up just after C, the sentence beginning the objections in principle, could you please read from there to the end of the following paragraph, 155? So again, the considerations are SIAC specific ones, and Lord Carswell draws an important distinction in kind between administrative review of this sort and adversarial civil litigation between private parties where the conventional burden of proof applies. Finally, Lord Brown, could we look first briefly at paragraph 168 of his speech. He says there, no doubt the effects of your lordship's judgment will spill over into other court proceedings designed to provide a judicial check on the exercise of other executive powers to place constraints of one sort or another on terrorist suspects in the interests of national security. So again, that indicates what he understood the scope of the determinations in A number 2 to be. And then at paragraph 172, he agreed with Lord Hope on the standard and burden of proof. So to summarise, all of the discussion about the burden and standard of proof for each of their lordships was expressly concerned with the application of the torture exclusionary rule in a forum with SIAC's specific highly unusual features. SIAC was not merely the accidental context for the House of Lords determinations, as Liberty has submitted. Its unusual features were the focus of the discussion and the basis for the conclusions. Lord Pannick said yesterday that none of the 7 members of the Appellate Committee focused on the specific factors of SIAC. In our submission, that is not right. Each of them did on these issues. And that is why we say, my Lord Legate's suggestion to Lord Pannick yesterday that there is an inconsistency between the Court of Appeal's acceptance on one hand that the torture exclusionary rule applied in the commercial court and its rejection on the other of the residual doubts principle is, with respect, not correct. It is plain from the judgment in A number 2 that the torture exclusionary rule had universal application, but the findings on the burden and standard of proof in A number 2 did not. Now we say the residual doubts principle, which was set out squarely in the context of Lord Hope's and Lord Rogers' discussions on the burden and standard of proof, must be similarly understood as intended to be limited, not to SIAC alone, but to forums that share SIAC's relevant features, the features their lordships were interested in. There is just no basis in the judgment for seeing it as intended to apply more generally when read in context. And there is a further specific reason, we say, for concluding that the residual doubts principle cannot carry across to proceedings such as these, which is that the burden of proof finding does not carry across, and the residual doubts principle in SIAC is, we say, dependent on the burden of proof finding. To take that in stages, I've shown your lordships the House of Lords finding on the burden of proof was not that an unconventional approach is appropriate whenever torture is alleged, but that an unconventional approach is appropriate in SIAC, given SIAC's special features. 3 features, we say, featured in the analysis in particular. First, the particular difficulties a Section 25 appellant in SIAC faces proving anything about the material relied on against him in circumstances where he cannot see that material. Secondly, the enormity of what is at stake for a Section 25 appellant in SIAC. And thirdly, the capability of the tribunal to treat the issue in an inquisitorial fashion rather than adversarial fashion in circumstances where the body that uniquely has access to the necessary lines of inquiry, namely the state, is a party before it with a duty of candour. Now, Shagang does not suggest, and has never suggested, that their lordships' findings on the burden of proof in SIAC can carry over to proceedings such as these. On the contrary, Shagang positively asserted at trial that this approach would not apply to ordinary civil proceedings. And if I can ask you quickly to turn up additional volume 117 MS 456. This is Shagang's skeleton argument at trial. And at the bottom of 456, you will see Shagang making the submission. There is a strong argument in a case such as the present that where a plausible case that relevant confession evidence was obtained through torture is raised, the burden then falls on the party seeking to rely on that evidence to prove that the relevant evidence was not so obtained. And then he says C, and the minority speech of Lord Bingham. And then if you look at footnote 52, what is said is that the court was split 4-3 on the question of the standard of proof, the majority agreeing with Lord Hope. The The minority, however, considered that if a plausible reason was advanced as to why the evidence may have been obtained by torture, then SIAC must refuse to admit the evidence if it concluded there was a real risk that the evidence was obtained by torture. In relation to the majority decision, it should be noted that the context of the burden of proof discussion was a decision by SIAC, a tribunal whose powers were likened, at paragraphs 155 to those of an administrative board. It is not at all clear from the majority decision how their approach would work in a trial in which the judge has no inquisitorial powers. Turning then to Shagang's closing submissions at trial, MS 520, you can see they followed it up in this way. At the beginning of paragraph 5, it is Shagang's case that once it has raised a plausible case that the confessions were procured by torture, the burden then falls on HNA to establish on the balance of probabilities that the confessions were not so obtained before they can be admissible in evidence. And then paragraph 6A, number 2, that is, was a decision in the particular context of a SIAC hearing where a conventional approach to the burden of proof was neither appropriate nor apposite. And then the references to paragraphs which I have shown, my lords. It is also important to note in this regard both the ability and duty of the SIAC to investigate for itself, if necessary, the allegation of torture. And then footnote 4 to that, see further paragraphs 143 to 144 of the decision. Those are the paragraphs of Lord Rogers' speech that I have shown your lordships. And SIAC itself will wish to take an active role in suggesting possible lines of investigation. The commercial court, of course, has no such function or ability. That was in the context of Shagang's argument that the burden of proof should fall on HNA. Now, as your lordships know, the judge declined to determine that issue. Shagang raised it by way of respondent's notice, but failed in the Court of Appeal and was refused permission to appeal to this court on that issue. So not only is there no dispute that an ordinary civil judge cannot and should not, where the torture exclusionary rule is raised, suspend the burden of proof and approach the matter inquisitorially like SIAC, it is now settled law that Shagang having raised the allegation of torture, the burden fell on Shagang to prove it. Now that is significant, we say, because on proper analysis, it follows from the fact that the burden of proof is dispensed with in SIAC, that Lord Hoffman's binary principle in Re B does not apply either. What Lord Hoffman said at paragraph 2, as my lords have seen, is that the law operates a binary system in which the only values are 0 and 1. The fact either happened or it did not. If the tribunal is left in doubt, the doubt is resolved by a rule that one party or the other carries the burden of proof. If the party who bears the burden of proof fails to discharge it, a value of 0 is returned and the fact is treated as not having happened. Now that principle can't apply if no party bears the burden of proof. The binary principle depends on the burden of proof, and the burden of proof is a mechanism designed always to resolve judicial doubts so that the facts in issue are decided. In conventional proceedings such as these, with a conventional burden of proof, a finding that torture is not established is equivalent to a finding that torture did not occur by operation of the burden of proof. That is what the Court of Appeal held on application of Re B. What it means for there to be a burden of proof is that if the burden is not discharged, the fact in issue is treated as not having happened. But in SIAC, where no party bears the burden of proof, a finding that torture is not established is not equivalent to a finding that torture did not occur. There is no mechanism that automatically resolves the tribunal's doubt. It can be left in a state of doubt, and those doubts can therefore be carried forward without contradiction. Now, Lord Hope, we say in that paragraph 118, confirms that the possibility of a state of doubt is what underlies the residual doubts principle. He said, if SIAC is left in doubt as to whether the evidence was obtained in this way, it should admit it. Lord Roger, similarly, said when everything possible has been done, it may turn out that the matter is left in doubt. But in ordinary civil litigation, where the ordinary burden of proof applies, there is no room for such residual doubt. Now, we respectfully agree with Shagang's submission to the judge in this case that to apply the same approach in conventional civil proceedings would be impossible without violence to basic tenets of such proceedings. First, the judge's job in such proceedings is to decide the pleaded issues, however difficult, if necessary, by reference to the burden of proof. Mr. Brown made reference to paragraph 21 of Al-Madeni in the supplementary bundle, which sets out that trite proposition. The conventional approach to the burden of proof is fundamental to allowing the judge to perform that function. Compare that with SIAC's role, which is a matter of assessing whether there are reasonable grounds for a certain belief. Burden of proof is not fundamental to the task or to the nature of SIAC's decision-making. Secondly, the judge's job in private civil proceedings is to decide the issues on the evidence adduced by the parties. It's entirely unclear how a civil judge could go about investigating torture in the way that SIAC can. SIAC has that capability because the state is a party before it, subject to its jurisdiction and with access to the necessary lines of inquiry. So the civil judge cannot dispense with the burden of proof or launch his own investigation into torture where it is raised. And since the conventional burden of proof applies, if the judge has found torture not proved, we say, to ask him to bear doubts in mind is to ask him to entertain inconsistent propositions. And that is the basis for the principle in Re B, which the Court of Appeal applied in this case. No inconsistency arises in SIAC for the reason I've given. The tribunal can legitimately entertain a state of doubt. So those are our submissions, addressing briefly the arguments raised against me on A number 2. Shagang's first reason for saying that the residual doubts principle is general is that the House of Lords unanimously decided that evidence obtained by torture must be excluded because of principles of general application. That is obviously correct, but we submit irrelevant. They did not consider that the exclusionary rule would apply in the same way or by the same mechanisms in all contexts. That is clear from the judgment. Shagang's second reason is that the House of Lords rejected the Secretary of State's submission that SIAC was a special case because of its unique statutory function. But the submission rejected was that the special aspects of SIAC exempted it from the torture exclusionary rule entirely. The House of Lords was obviously not of the view that special aspects of SIAC could not properly inform the application of the torture exclusionary rule in SIAC. On the contrary, they obviously did. Shagang's third reason is that the House of Lords made reference to the case, the Hamburg Criminal Court of Appeal case of Al-Motadasek, and Liberty also rely on that point. Now, if we can turn that up briefly, the translation is in the bundle, Authorities Bundle 472, MS 2940.
Could you give me the MS number again, please?
MS 2940.
Thank you.
Beginning of the translation. Now, the conclusion that their lordships picked up on in A number 2 is found at the very end of the judgment. So the court, you will recall, decided that torture was not proven on the evidence and admitted the summaries. But at the very end of the judgment, in the final 3 lines before the end, they said the Senate is therefore aware of the problems of the possible use of torture measures and will bear this in mind when assessing the information contained in the summaries. The first point we make is that that is again a single line which was not the subject of argument or submission in the Hamburg Court of Appeal authority, and it's not clear from the translation what it means. But in any event, as regards their lordships' reliance on that principle, the point is that this was also proceedings involving the liberty of an individual, a state party, a national security context with all that that entailed, and the exercise of some form of inquisitorial jurisdiction on the issue of torture, because it is clear from the translation of that judgment that the court itself undertook extensive inquiries of its own with both domestic and foreign state authorities. So their lordships' reference to this case in A number 2 is obviously not a reason, we say, to think that the residual doubts principle was intended to apply to ordinary civil proceedings between commercial parties in the commercial court. Next, Shagang suggests that the Court of Appeal's approach is inconsistent with the constitutional abhorrence of torture because it would mean that other than in the context of a SIAC determination, judicial doubts about whether there had been torture must be ignored in assessing hearsay evidence, despite the undoubted difficulties of proving torture. 3 points in response. First, constitutional abhorrence for a certain form of behaviour does not require a civil court to take into account unproven possibilities. In Re B, Baroness Hale said, and this is set out at paragraph 98 of our written case, and I don't ask you to turn up the judgment, but she said, children have both the right to life under Article 2 and the right not to be subjected to torture or inhuman or degrading treatment or punishment under Article 3 of the European Convention on Human Rights. States are required to take measures to protect them, principally in form of effective deterrence through the criminal law, but also through taking steps to remove them from an abusive situation about which the authorities knew or ought to have known. But there is nothing in those cases to suggest that the authorities are failing in their duty to protect children from inhuman or degrading treatment because they are unable permanently to remove children from their families on the basis of unproven allegations. We say similarly, there is nothing in the law to suggest that courts are failing in their constitutional duties as regards torture if they cannot decide commercial disputes by reference to unproven allegations of torture. The second point is that the lordships did not find, and the appellants did not even submit, as I've shown you, that the rules of procedure should be dispensed with because of the special difficulties proving torture, rather than because of the special aspects of the SIAC jurisdiction. And the third point is that torture may be difficult to prove, but so are many other things. And in ordinary adversarial civil proceedings with equality of arms, the difficulty of proving something is not in general a reason for dispensing with the probabilistic standard of proof or the conventional approach to the burden of proof. Turning now to Liberty's submissions, Liberty are intervening, they say, because of concerns about the knock-on consequences of the Court of Appeal's judgment for non-commercial cases. Now that is curious, we say. Our position is that the Court of Appeal's judgment was about the application of the rule in commercial cases. It leaves A number 2 untouched. So one would expect Liberty to be siding with us on that issue. In any event, Liberty are wrong, we say, to say that the residual doubts principle in A number 2 was intended to apply in conventional forums. They're wrong to say that there was nothing in the judgments to suggest a special rule was being created, as I've sought to demonstrate. We agree that the principle is not limited to SIAC, but it is not fully general, and in particular is not applicable on the basis of A number 2 in ordinary commercial proceedings. Liberty suggests that the principle may have been applied in closed judgments in similar jurisdictions and suggested that this court may derive assistance from such judgments. But by definition, those are all forums in which draconian measures are being reviewed and closed evidence has been relied on. So none are remotely like ordinary civil litigation. Liberty says there is nothing in the judgment to suggest that their lordships were creating a carve-out from the normal rules, but they were, we say, expressly carving out the approach to the burden of proof, which is crucial for the reasons explored. Liberty say there is no good reason why the ordinary civil courts should apply a different approach. Not so, we say. It creates a fundamental inconsistency for a civil judge if the residual doubts principle is applied in an adversarial forum with a conventional burden of proof. Liberty say that the Court of Appeal proceeded on a mistaken assumption of SIAC's jurisdiction and that it doesn't only hear Section 25 appeals. Well, that is right, but the House was for that reason careful to confine the ambit of what it said, and in any event, all appeals in SIAC are likely to involve closed evidence, have implications for fundamental liberties, and have the state as a party, crucially. Liberty say, finally, that lingering doubts may be just as relevant to the question of reliability before a civil judge as before SIAC. That may be right, but in civil litigation you have the burden of proof and the binary principle, the very object of which is to ensure that doubt is always resolved. There are, as a matter of law, no lingering doubts in civil litigation. There is also, we say, no strong moral imperative, such as exists in SIAC, to carry such doubts forward or to bear them in mind. Those imperatives derive from the inequality of arms, the use of closed material, the very serious consequences for the individual, and those things simply do not carry across to a conventional forum. And finally, a conventional judge does not, as I have emphasized, have the same capability to investigate an allegation of torture without the state before it as a party. So for those reasons, we say that if the court is with us on Re B, then A number 2 provides no alternative basis for it to conclude that the retrial judge on remittal must be entitled to take doubts about torture into account in evaluating the evidence. My Lord, Lord Legate.
Sorry, I was waiting for it to unmute. Just standing back from it all, Ms. Boyd, what do you say in a nutshell is the justification for requiring the possibility that a statement was procured by torture to be ignored by a judge when assessing its reliability, particularly when other relevant possibilities that other lesser forms of pressure or inducement were used can be taken into account? It seems completely the wrong way around, doesn't it, to say that the most serious potential form of factor that might undermine reliability is something that the judge should, as a matter of policy or principle, turn a blind eye to.
Well, my lord, he is only turning a blind eye to it if he has been asked by the parties and to determine the issue and has determined it. And that is what he, as the judge in the case, has been asked by the parties to do. And he then bears the consequence, he and the parties bear the consequences of having made a determination to that effect in the context of the commercial court where the ordinary consequences follow. It is not back to front, upside down, as my lord has suggested. The parties don't have to plead the exclusionary rule. They don't have to try to get the evidence excluded. They can instead invite the judge to take the relevant facts into account in relation to weight. And that is true not only of the more serious allegations in relation to which the opportunity also exists to try and get it excluded altogether, but in relation to the less serious sorts of allegation as well. So, my lord, we say it is simply a function of basic precepts of civil litigation. Where the judge has decided something on the balance of probabilities, he has decided it.
But ultimately, that the point you're making, Ms. Boyd, is that Re B, you say, applies to facts put in issue for the purpose of admissibility.
Yes, my lord. As I say, my submissions proceed on that assumption.
Yes. Well, thank you very much, Miss Boyd, for your assistance. Lord Panic.
Thank you very much, my lord. Can I go back to Mr. Brown's submissions? First of all, he contends it is a proper basis for an appellate court to intervene where the reasoning of the trial judge is defective. And there's no dispute from us about the principle. However, we would respectfully caution the court as to its application. And that's for the reasons that were given in the case on which my friend relies, Datec Electronics. If the court would go back to Datec at MS page 1469, your lordships will see the observations, the speech of Lord Walker of Gestingthorpe, who expressed doubts about the conclusion in that case. And I would draw attention to page 1330 of the report, just under letter A, where his lordship says, in principle, there are clear distinctions between findings of primary fact, factual inferences, and the evaluation of factual matters, but in practice, they often start to run into one another. An appellate court should be cautious about differing from the trial judge in any of his findings for the reasons explained in the well-known cases. In my submission, an appellate court will not allow a party to present as a challenge to the reasoning of the judge what in truth is a complaint about the weight at which the judge has given to relevant factors. And that, with all due respect, is what has happened in this case. But we say the judge took account of the confessions, he took account of all the other relevant evidence, he weighed it up, confession evidence as against the other evidence, and he arrived at a conclusion which was open to him on the evidence that he was not satisfied that there was a bribe. My friend Mr. Brown made a number of criticisms of the paragraphs of the judgment, paragraphs 87 through to 97. Could we go back for one last time to MS page 224? My friend made a criticism of paragraph 88, where the judge referred to the confessions and said he was taking them into account. My friend made a criticism that the judge only dealt in detail with the confessions of Mr. Zhu. The judge was, of course, very, very well aware that 3 individuals had confessed. He refers to the 3 confessions in 89 and indeed in 97. But more importantly, the judge sets out in detail which my friend did not criticise, at paragraphs 25 all the way through to 55, the detail of the confessions that had been made. And it is unrealistic in the extreme to suggest that the judge, when he turned to assessing the evidence, did not take all of the confessions into account when he had himself set them out so fully in what was a comparatively short judgment. Then at the end of paragraph 8, the judge took into account that all the 3 men who had confessed had also denied that there was bribery. And again, one needs to read that sentence with what precedes it in paragraphs 25 through to 55, because it is there that one finds the detail that although there were confessions, each of these men had repeatedly also denied that they had committed bribery. Then at paragraph 89, the judge drew attention to the fact, as a factor going to the weight of the confessions, that each of the three of them, when they first referred to a bribe, did so without a lawyer or other representative present. And the Court of Appeal accepted paragraph 71 of its judgment, MS 204, that this was a relevant factor to take into account. My friend criticised that reasoning, but the obvious point that the judge was making is that once you have made a confession, it is not going to be easy formally to resile from it. That's a point the judge was entitled to take into account. It's not decisive, but the judge does not suggest it was decisive. Then there was a criticism of paragraph 90. I dealt with this in opening. I do not accept that the judge is having regard to torture matters in paragraph 90. I answered a question in relation to this from my Lord Hamblin in opening. The questioning of the PSB officers would also be of assistance to assess whether, if so, to what extent, the admissions were induced by the prospect of a lenient sentence. But in any event, the Court of Appeal rightly made it clear that it did not regard paragraph 90 as in any way decisive or as justifying in itself a remission of this case. And moreover, in their written case, that's HNA's position too. MS 122, paragraph 20, subparagraph C, and also paragraph 79. Then the judge turns to the commercial context points, paragraphs 91 and 92, as to why a bribe was inherently implausible in this context. And the judge sets that out at 91, which again has to be read in my submission together with the earlier paragraphs, particularly 18 and 19, which deals with the market. My friend had a criticism of the first sentence of paragraph 92. But the first sentence in my submission is mentioned simply as a prelude to the point which the judge then makes in 92, that the Charter Party was approved substantially through HNA's own procedures. And that's a relevant point. Nobody complained about it at the time. Again, not a decisive point, but it's a point the judge is entitled to weigh in the balance. It all goes to the plausibility of the confessions, as my Lord Hamblin put to my friend. Then there was a point taken on 94, context. Well, the judge is weighing up all of the factors that he's referred to in context. He's looked at the fact there were confessions, he's looked at the surrounding circumstances of them, and he's looked at the factors which suggest that a bribe is implausible in this context, and he was entitled, in my submission, to do so. Paragraph 97, my friend criticised, but that's the judge's recognition that the wish for leniency was a credible reason why the confessions may have been made, even if there was no bribe. And the reason why the judge addresses the point in that way is because, as he says, he is responding to HNA's argument that there is, quote, no credible reason why the individuals should falsely confess to crimes which they did not commit. We say, in any event, the judge was perfectly entitled to deal with the matter in that way without making a finding. He's not obliged to make a binary finding on such an issue. My friend accepted, in answer to my Lord Legate, that the confessions are hearsay evidence, and under Section 4, it was for the judge to assess their weight in all the circumstances, not make binary findings on such matters. And that's what HNA accept in their written case, paragraph 83, MS 151. My friend then said, well, there must be some evidence that the confessions may be unreliable. My lords, the judge had a great deal of evidence that the confessions may well have been caused or influenced by the wish to secure a lenient sentence in a legal system in which the prospect of an acquittal is very low. As my Lord the Deputy President and my Lord Hamblin pointed out, the judge referred to the evidence in relation to Mr. Zhu at paragraphs 38 of the judgment is MS 217, paragraph 41, which I don't think has been specifically focused on, but paragraph 41, Mr. Zhu, this is MS 217, Mr. Zhu had instructed Mr. Guo to proceed to defend him on the basis of a guilty plea, observing that the authorities would never admit that he'd been forced into giving a false confession. Your lordships may also want to look at the agreed statement of facts and issues. Paragraph 14 refers to the interrogation records, and in the last 6 lines in paragraph 14, it's MS page 60, MS 60, agreed statement of facts and issues. Paragraph 14, in the in 6 lines from the end, the interrogation records record that Mr. Zhu's account was given voluntarily, also records that Mr. Zhu was willing to confess his involvement for leniency. That's what the record says. Similarly, at paragraph 19 on page MS 62, again, Mr. Zhu was being questioned by the PSB. Again, this is a summary of the interrogation record, and the final sentence, he, Mr. Zhu, said he'd subsequently confessed the full extent of his crimes for leniency. If one needs it, we have set out in detail in our written case, MS 81, can I just ask the court to turn it up? MS 81, paragraphs 9, 10 and 11, the references to all the occasions where leniency is mentioned. And if your lordships look at MS 81, paragraph 9, the confession evidence of Mr. Zhu, one sees in subparagraph 1, he's told he will get leniency, and he signs up to the confession for leniency. Similarly, subparagraph 3, I won't read it all out, and subparagraph 4. Mr. Gia T at paragraph 10, subparagraphs 1 and 2, and Mr. Shen at paragraph 11, subparagraph 1. It is simply impossible for my friend to suggest that the judge had no evidence that these men were confessing in order to secure leniency, such that the judge could take that into account as a possible motive. We note that my friend made no attempt to defend the Court of Appeal's extraordinary statement at paragraph 78 of the judgment, MS 205, that the Court of Appeal could not understand why an innocent man would confess to a crime he had not committed. My friend then relied on the pleadings. The Court of Appeal itself was rightly unimpressed by that argument. My friend took your lordships through the Court of Appeal judgment at length. He did not, I don't criticise him, I merely explain why I'm taking you to it. He did not read out MS 203, paragraph 66 to 68, where the Court of Appeal explained why the pleadings point is a very bad one. And it's a very bad one, not least because we did not have to plead all the points that we might derive from the evidence. We merely needed to plead, and we did, that there was no bribe. In any event, we did rely on the hope for leniency in the trial before Mr. Justice Knowles. Can I give your lordships the references without taking them, your lordships, to them? Our skeleton argument before Mr. Justice Knowles, MS 429, paragraph 53 and 55. Our closing oral submissions, MS 590, page 33 of the transcript, at line 21, down to page 34 of the transcript, at line 14, and in many other places. So we say this judge weighed the evidence, he considered the confession evidence, he made a judgment that was open to him on the evidence. This is in truth a case in which a party which has lost on the merits is seeking now to present as an appeal on reasoning a complaint which in truth is a complaint as to the merits. If I'm wrong on all that and there is to be a retrial, the question arises as to its scope. And my friend Mr. Brown then submitted that the Court of Appeal was correct to say that the judge had decided the question of torture adverse to my clients, even though my friend accepted in answer to my Lord Legate that a judge is entitled to treat the confession's evidence as admissible de bene esse. My friend said that didn't happen, but he accepted it was open to the judge to adopt that approach. It's open to the judge to ask himself whether in any event he is satisfied that there was a bribe, proceeding on a basis favourable to HNA, that there was no torture. We say, I won't repeat the submissions I made in opening, but we say that's what happened. The judge proceeded on the basis de bene esse that there was no torture. See paragraphs 101, 102 and 104. In any event, I repeat the point briefly put by my Lord Legate to my friend. If this judgment was so defective, then the whole of the case should be remitted. My friends cannot pick and choose which bits they wish to preserve. And that is particularly when the Court of Appeal's conclusion was that the judge had gone fundamentally wrong in that he did not decide the question of torture as the first issue. Then, in any event, my friend submitted, and he was asked about this just before lunch today by my Lord Burrows, my friend submitted that it would not be open to the new judge to take account of the risk of torture, a risk up to 50%. Now, I say that is a very surprising submission, because at most, this judge held, and I say he didn't, but at most he held, that the confession's evidence is admissible because torture was not proved on a balance of probabilities. But the weight of the evidence, once it is admitted, is dependent on all the circumstances. See, if one needs it, section 4. And it would be extraordinary, as I think my Lord Legate put to my friend Miss Boyd a few moments ago, it would be quite extraordinary if the judge under section 4 is obliged to assess the weight of admitted evidence by reference to all other considerations, but to ignore the risk that that evidence may have been produced by torture. It would be particularly bizarre in my submission when we know that this judge was himself at the very least concerned that there may have been torture. See paragraphs 101, 102 and 104. My friend's case, and it's Miss Boyd's case as well, is that all of this is resolved by Re B. And I made submissions in opening that Re B recognises that what is a fact in issue depends on the context. That's what Re B says. And my friend Mr. Brown submitted that the High Court, these were his words, the High Court, the Commercial Court, has determined the fact in issue. But one needs to be more precise. At most, what Mr. Justice Knowles determined, I say he didn't, but at most what he determined was a fact in issue as to admissibility. In other words, has Shagang satisfied him on a balance of probabilities that there was torture? That is more than 50%. And that does not tell the court anything as to the weight of this evidence other than that there is less than a 50% risk that this evidence was produced by torture. So I say Re B does not assist for the reasons I gave in opening and for those reasons in the circumstances of this case. Finally, on Mr. Brown's submissions, he drew attention to fresh evidence. I made the point in opening, the Court of Appeal did not suggest that any of the fresh evidence of itself required a retrial, and unsurprisingly so, the fresh evidence is of marginal, if any, relevance other than as to torture. I accept it's plainly relevant to whether there was torture, but unless the case is remitted, the question of torture does not arise. Finally, Miss Boyd made submissions on A number 2, and her submissions are a reflection of Mr. Brown's submissions in relation to Re B. We say our approach is consistent with the common law's abhorrence of torture as recognised by the Appellate Committee in A number 2. And we say it would be inconsistent with that of abhorrence for the law to be that the commercial court is not to take account of the risk of torture in assessing the weight of evidence once it is admitted, especially given the difficulties of proving torture. It would be very surprising if in my submission if Section 4 did not apply in assessing the weight of evidence in the light of risks that the evidence was the consequence of torture, or looking at Section 4, MS 1330, in estimating the weight to be given to the confessions and assessing the reliability or otherwise of that evidence. Ms. Boyd said that although the exclusionary rule prohibits the use of evidence produced by torture in all cases, she does not suggest that the exclusionary rule is a rule specific to SIAC. She suggests a different approach is to be taken to the assessment of the weight of evidence in a case where it cannot be proved that the evidence was the result of torture. We say it would be very surprising if that secondary principle were not also to apply to all courts, not least because evidence adduced by reason of torture will almost inevitably be hearsay evidence. It's very difficult to think of evidence adduced by torture that is not hearsay evidence, and Section 4 would apply. In any event, Lords Hope and Roger, for the majority, each relied for their approach on the decision of the Hamburg Criminal Court, and in my submission it would be a very fine line indeed to say that different rules apply depending on whether the proceedings are criminal or they are civil. But we take our stand primarily on Section 4 and on the fact that this judge, pushing it at its highest from HNA's point of view, determined only that this evidence was admissible. That is the only fact in issue of relevance. I have taken almost all of my 30 minutes, but I'm very happy, of course, to seek to answer any questions that any of you lordships have, but that's what I wanted to say in answer to my friend's submissions.
Lord Panic, Mr. Jaffe drew our attention to the historical distinction between the role of the judge and the jury, one as the umpire of the law and the other the finder of facts. Does his submission chime with yours? Is it a submission that you adopt as helpful, or do you have anything to say about it?
Well, I do adopt it, and the reason I adopt it is that the law cannot be different when the same individual is determining admissibility and weight. If one has a jury trial, the judge determines admissibility, the jury will then assess the weight of all the evidence. Today, in this case and in almost all litigation, the judge performs both roles, but they are still distinct roles, and it is important to recognise that where the judge determines admissibility, he or she has only determined that he's not satisfied that the evidence was the result of torture. The question remains, what weight does one give to it in all the circumstances of the case?
Thank you. Lord Hanlon?
Lord Panic, on the question of whether the judge can take into account the risk of torture when assessing weight, you've dealt with that purely under issue 2 on the basis of remission. But if you're right about that, is it also potentially relevant to issue 1, even though it wasn't a factor the judge expressly took into account?
Well, it's relevant to issue 1 in the sense that the Court of Appeal were criticising the judge for the general approach that he was taking. The judge on our analysis was not deciding questions of torture at all, but he was perfectly entitled, my submission, in assessing the weight of all the evidence, to have regard to the risks of torture.
I don't think my colleagues have any further questions. Well, the court is very grateful to counsel for their clear submissions, and also to those who assisted counsel in the preparation of their cases and the papers now in electronic form. The court will take time to consider submissions and will produce a judgment in due course. The court will now adjourn. Thank you.
Thank you very much, my lords.